Tēnā koutou, tēnā koutou, tēnā koutou katoa. My name is Claire Breen. I'm a professor at Titiro at the University of Waikato. I'm here, and I'm going to start by saying, actually, I've gone off script a little bit. I'm not going to be talking about what's happening specifically in the Pacific, but I do want to talk about the relationship between human rights and peace and security, and the role of culture as part of that. It's something I was thinking about late last week, and I ditched a whole lot of slides because there's an awful lot of people here in this room yesterday and today who are probably better equipped to talk about those things. In terms of my background, I guess I research and I teach in the area of human rights specifically, and I co-teach with Al in armed conflict. And I think it was mentioned yesterday, we wrote a book together that was published last year. Why talk about human rights as part of peace and security? So my answer in some ways is a legal answer. It's because it's in a legal document. And it is in the founding document, it's in a treaty, it's legally binding, it's in the Charter of the United Nations. So if we look at Article 1 of that treaty, that legally binding agreement, we see that one of the functions of the UN is to maintain international peace and security. One of its purposes, and this is where we do a bit of a deep dive in drawing out the importance of human rights, is that international cooperation in solving problems of an economic, social, cultural, or humanitarian character. It's one of the purposes of the UN. And it's to promote also and encourage respect for human rights and fundamental freedoms without distinction. Later on, and there's a few references here and there, but I've just picked out one. Article 55 talks about the importance of international, cultural, and educational cooperation and the achievement of international cooperation and encouraging respect for human rights. So the two are very closely entwined in the wider picture of peace and security. Why, I guess, human rights? Why the Charter? If we go back and jump into the stream of history, I'm going to jump in 1945. We have the end of the Second World War, and we have the emergence of a number of documents focusing on people. We have the Genocide Convention, the Geneva Conventions dealing with the laws of armed conflict, and we have the Refugee Convention. And again, we have I guess, the connection with the UN Charter. So people do lie at the heart of this also, and their human rights, for that matter. In terms of human rights language, and in terms of legal documents, we can see that connection between rights, freedom, justice, and peace in the Universal Declaration from 1948. Within that, there's a whole series of rights, civil and political, I'll talk about that, economic, social, and cultural rights. The Declaration gave rise to a legal framework, the UN legal framework, and there are regional ones, but I just want to talk about the UN one for today, that gave rise to two further treaties, two further legal documents. And again, we see I guess the connection back with the founding principles of the UN, the importance of dignity, human rights, and the relationship with freedom and justice and peace. So we have these and these two documents from 1966. And they were the forerunners, well, kind of a series of specialized treaties dealing with the efforts to eliminate discrimination on the basis of race and gender, to tackle the problem of torture and enforced disappearances, to acknowledge the specific interests, needs, and rights of different groups in society, children, migrant workers, persons with disabilities. And more recently, we have the United Nations Declaration on the Rights of Indigenous Peoples as part of that tapestry of human rights. All of which, by the way, make reference to cultural rights. But part of the development, part of the telling of this story is that despite that connection between peace, security, dignity, justice and rights, human rights law evolved somewhat separately, I guess from 1945 and 1948, and I guess global politics played a little part in that. There was always that focus on state sovereignty, and that this body of law was developed to regulate rights and obligations at the national level. So we have treaty monitoring bodies that work to interpret rights. They're not courts, they're not judicial. And the thinking was at the time that we would have this international framework of human rights that would be implemented at the national level. So here in Aotearoa, New Zealand, we have some legislation, the Human Rights Act, the New Zealand Bill of Rights Act. But that only, I guess the Bill of Rights Act only takes some sorts of rights and makes them part of domestic law, and I'll come back to that point perhaps a little later on. But despite the separate evolution, there has always been a recognition within the UN about that relationship between human rights and armed conflict. How could you go past that when you think about the founding language of the organization and what the Charter had to say? But I suppose there was always going to be limits to that, because the respect and promotion for human rights as a principle, a framework of international law, was always going to bump up against other long-established principles of international law. And so the ICJ in the mid-1980s said that, that's International Court of Justice, a UN body, said that human rights violations were not a premise for armed intervention by states. So a lot of stuff I could say about that, but I'm going to move on because it gives, we talk about humanitarian intervention and the right responsibility to protect, but I'm going to park that. But it tells us that there is a limit around situations in which armed force is appropriate and not appropriate. And the point was, if there are violations of human rights, it's up for the treaty monitoring bodies and the various other UN mechanisms to respond to that. Armed intervention wasn't the way to go. But it doesn't shut down other avenues for the international community to deal with that threat between international peace and security and human rights. And so there has been a role within the UN, and if we look at the Security Council as the main body in charge of maintaining international peace and security. Early on in the piece, and then there was sort of silence up till the early 1990s, the Security Council then picked up that notion, or it recognized, articulated, that gross human rights violations could signal descent into civil conflict. There's wider relationships evolved, particularly, I guess, in the early 1990s and the early part of this century, where the Security Council was able to draw on other parts of the UN that were working in the human rights arena. And so we can see the Human Rights Council playing a role in that, I guess, in more recent history and in very recent history. When the Security Council starts talking about making those connections between civil conflict or intrastate conflict and human rights, it may be prompted to a response in terms of Pacific settlement of disputes or sort of traditional peacekeeping operations, or those that allow for the use of all necessary force, our peace enforcement, our Chapter 7 responses. And in the selection of cases, and it's, gone back. In those situations that I've identified, they're a combination of international and interstate conflict. There, the Security Council made those connections between the threat to international peace and security and internal conflict or international conflict. And then as time evolved, human rights language became part of those mandates in a different way, as the Security Council mandated those peace operations to respect humanitarian law, but also human rights law. When we think about peace and security, we might think about the things that Al talked about yesterday. But inevitably, we also need to think about things we might think less about, but I think are part of human rights law: water, food, culture. When we think about violations of human rights in the context of conflict, we might think about torture and detention, but we might also think about access to food, water, health, education, and culture. That shouldn't be a surprise in some ways if I focus on the notion of culture, because humanitarian law has long recognized the importance of cultural property and the protection of cultural heritage. We can see in 1998 the specific focus on the protection of culture and a violation of that as being a war crime. We can see the Security Council in more recent years has condemned the destruction of cultural heritage and has put it in as part of the mandate for peacekeeping operations. So when we think about culture, we are thinking about dignity and rights. And we can see some of that language being emphasized and coming through in various other parts of the UN that talks about the importance of respect for cultural rights and why it is important for human dignity. And I guess that quote there from the Al-Mahdi case and the statement of the prosecutor there demonstrates, I think, quite clearly why attacks on culture and the destruction of cultural heritage are just more than the destruction of bricks and mortar. So human rights law, somewhat late to the piece, has started to respond to that, and the Human Rights Council in more recent years has talked about the importance of protecting cultural heritage. In 2009, the UN set up a particular mechanism, a UN Special Rapporteur on cultural rights. And we see some clear acknowledgement of the importance of cultural rights there. And when we think about culture, and this is a very brief overview, but we think about culture as access to culture, participation in cultural life, the practice of one's culture. And all of that language is captured in these treaties that I mentioned a few minutes ago. There we have, and other instruments, they all talk about the right to culture, and some talk about the importance of protecting cultural heritage. This quote from 2018, I think I've put it in because when I was putting this together, the quote comes from a report. The report came from a meeting that was held in Northern Ireland in about 2014. And it was talking about, I guess, the importance of culture and the importance of, amongst other things, education, teaching history. So I was thinking a lot about yesterday, and memorialization. Culture plays a key role in that nexus between peace building, security, and humanitarian efforts. So I guess today, drawing on the wonderful conversations from yesterday and my own thinking in this area, I would like to give, emphasize the importance of cultural rights as part of this wider conversation that we're here to have yesterday and today. There's two things. I wish I had another slide and 2 other minutes, but I decided I would leave with the importance of memorialization as part of transitional justice and reconciliation. More widely, and this quote, so actually it was kind of coincidental last week, relates to the work that is happening here, and it was interesting to be in yesterday's presentations where I was able to listen to what has happened and what might be happening in the future. But the museum, I suppose the roles of the museum and the memorialization of the histories of Indigenous peoples plays a key role. And the one thing, my last sort of 30 seconds was, yesterday I really wanted to say something when I was listening to the importance of teaching of history and education. Because if we aren't able to know those stories and share those stories, then I think we are losing a very valuable, it's more than valuable part of our culture and our history. Thank you.